Good morning, everybody, and good evening to our colleagues in India or the United States or wherever you may find us. We are excited today to have one more iteration of our Khaitan Company Legal Digital Roundup. The purpose of today's conversation and others is to provide an update of a variety and sundry of activities. It's done in a nightly news format. We are pleased to have a handful of KCO partners and experts to talk through our issues. The slides that we will show today will be made available afterwards, and we will certainly have some questions at the end of the program. So in the meantime, I'm handing it over to my co-MC, Arshad from KCO, based out of Silicon Valley. Paku, over to you, sir.
Okay, thank you very much. And ladies and gentlemen, thank you so much for joining us today. We very much want to thank the U.S. India Business Council and the U.S. Chamber of Commerce for giving us this opportunity. But most of all, we want to thank you for coming on board today. And as Jay said, we are going to treat this as a newscast. We've done this, I think, 7 or 8 times, Jay, and it's gone really well. The reason we picked this kind of format is we're talking about a variety of disparate topics, and my colleagues at Khaitan Co will essentially be your reporters, and Jay and I will serve as your anchor persons for today's show. So that being said, Jay, if we can move to that slide. Just there we go, and move to the second one, please. Let me just introduce you to our correspondents, and we're going to be going left to right and then top to bottom, and this is essentially the order of the presentation of today's newscast. So starting from the top left, we have Shobit Chandra from New Delhi, and he's in our Telecoms, Media and Technology, or TMT, area at Khaitan Co. Next, we have Raghav Kumar Bajaj, who's in our tax department in New Delhi. Moving on to the very right of that top row, we have Supratim Chakrabarti, or Supro as we affectionately like to call him. He's actually one of the country India's data privacy national leaders, and today he's going to be talking about some issues with intermediary guidelines. And then moving down to the next row, we have Achint Kaur in our New Delhi office, and she's in our corporate department. And finally, our last substantive speaker will be Nishad Nadkarni, who's an IP partner in our Mumbai office. And then the fellow on the very right bottom is me, your moderator. And as Jay said, I'm actually in California. The rest of my colleagues are based in India. So Jay, if we can move to the next slide, please. And so let me just give you a very, very quick outline of today's program. And we're going to each of our reporters are going to take about 5 minutes or so. So first we've got Shobit, who's going to talk about the Department of Telecommunications guidelines for captive non-public network and spectrum leasing to enterprises. And we also had a late-breaking development on Saturday that Shobit is going to also raise with you. Next, we've got Raghav talking about the Control Board of Direct Taxes guidelines in relation to tax deducted at source on payments for VDAs, or virtual digital assets. Then we will have Supro talking about draft amendments to the Information Technology Intermediary Guidelines and Digital Media Ethics Code. These are issues that are also very much in the fore in the United States and very much in the fore in India. So Supro will guide us there. Then finally, our fourth presentation will be Achint talking about SEBI, or the Security and Exchange Board of India's cybersecurity framework for mutual funds and asset management companies. And then finally, Nishad will take us through the guidelines for the Central Consumer Protection Authority on the prevention of misleading advertisements and endorsements. So that's our quick outline. At the very end, as Jay said, we'll take 5-7 minutes or so for your questions. Please just type them in and we'll take them if we have time. If we can't, we'll try to get to you by email. So Jay, I think let's move on to the next slide, and we're going to turn it over to Shobit to talk about the guidelines for captive non-public network license and spectrum leasing for enterprises. And Shobit also walk us through the late development on Saturday by the Department of Telecoms on its new proposed legal framework. Over to you.
Many thanks for that, Paku, and a very good morning and good evening to everybody who's joining us today. What I'll be talking about is a very buzzing development in the telecom and tech space. The DOT has recently issued its guidelines for the grant of the captive non-public network license. And it's also laid down certain terms and conditions for leasing of spectrum by enterprises. So to kick things off, the definition of the captive non-public network license is basically refers to a terrestrial wireless telecom network established for captive use within a specified geographical area. Now, one may ask, what is the need for this to have taken place, and what is it that has catalyzed this process so quickly? So there was a consultation process that even the Telecom Regulatory Authority of India has been taking up in this regard, and there have been several representations from the industry for broadening the scope of spectrum usage by private enterprises, and also creating new avenues for maximum utilization of spectrum. And at the cusp of the fourth industrial revolution, where we have new emerging digital technologies like artificial intelligence, robotics, Internet of Things, mobile edge computing, all of these really provide enough impetus for this sort of framework to take place. In terms of scope, the CNPN license, as it's more shortly referred to, will be for establishing indoor isolated networks. And notably, this is for self-use and not for any commercial, not for providing any commercial services. In terms of the eligibility criteria for an entity to obtain this license, it's quite akin to how it is in the telecom licensing sphere. It has to be a company which is incorporated in India. And as a part of the application process, there's also a requirement to demonstrate that they are in control of the geographical area or the property over which this network is to be established. In cases where the spectrum is sought to be directly assigned from the government, there is also a requirement to demonstrate a net worth of 100 crore rupees, which is in the range of about 13 million USD. As I mentioned earlier, the area of operation for this license will be a property or a geographical area which is owned or leased by the licensee. As far as fees are concerned, the DOT has gone a step further in terms of the flavor that has been flowing since last year in terms of reforms and cut downs on financial requirements. So the DOT has adopted the TRI's recommendation here and has clarified that there'll be no entry fees, no license fees, or spectrum usage charges that would be payable in such cases. There's only a one-time application fee of 50,000 rupees that would have to be paid, and that's how we get the license. Now, the framework envisages about 3 models for acquisition of spectrum by enterprises. The first one being leasing of IMT spectrum, which in colloquial terms just refers to 3G or 4G spectrum, which can be taken from TSPs that hold an access service license. CNPN can also be provided by a TSP with an access service license as a service, and that again will be dictated by the terms of the contract between the enterprise and the TSP. There's also a provision where there can be direct assignment of spectrum by the Department of Telecom, but the modalities and the nitty-gritties of that will flow down in due course. In addition to that, there are certain general conditions regarding procurement of equipment, establishment of equipment in terms of which area they can be established in. I beg your pardon, and the kind of other clearances that may be required from authorities, as have been set out on the slide in front of you. There are certain security conditions that need to be complied with as well, particularly with regard to procurement of telecom equipment, as well as giving access for lawful interception and and verifying bona fide use of such services. Um, in addition to this, as Paku was mentioning, there's also a new consultation process that has been initiated by the Department of Telecom over the weekend. And for that, the submissions are due. There's still about a month's time to go for that. What the DOT is looking to do is to revamp the legal and regulatory framework relating to telecom in India. They've issued a fairly short and simplistic consultation paper as of now, where they've touched upon the various areas where they would want to invite comments from the public. And there are some areas such as the revamping of the licenses, the Telegraph Act itself, mergers and acquisitions, how insolvency of telecom companies has to be dealt with, and so on and so forth.
Shobit, thanks very much for that, and thank you for that update on the late breaking news from this Saturday. Let me ask you a question on the CNPN. And for our audience, can you give some real world practical examples of how this can be put to use by our colleagues in the audience?
Sure. So, in fact, I mean, as I mentioned earlier as well, I mean, the need that really the stepping stone for this regime to take place was the cusp of the industrial revolution that we are at right now, with so many emerging technologies in the forefront, like AI, robotics, machine-to-machine communications, Internet of Things. All of these will require a great deal of spectrum, and especially with the 5G auctions going on presently, that's the precise use case which has been talked about world over as well. And in fact, even the TRAI has taken note of this in their consultation paper and said how industrial application is sort of set to take off with this sort of spectrum use by enterprises.
Great, Shobit. Thank you so much for that. Now let's move to our next slide, Jay. And we're going to have Raghav talk on the dreaded T word, taxation of virtual digital assets. So Raghav, take us through how VDAs are proposed to be taxed in India.
Thank you, Paku. Hello, everyone. So VDA taxation has been one of the most hotly deliberated topics in India in the recent past. And this is mainly because earlier this year, we introduced a specific taxation regime for cryptos, whereby a separate category was carved out for virtual digital assets, or VDAs as they are being referred to. So as you can see on the screen, this basically covers any information, code, number, token generated through cryptographic means, or non-fungible tokens, except where the underlying is a tangible asset subject to certain conditions. Recently, it was also clarified that digital assets such as gift cards, mileage points, reward points are not virtual digital assets. In terms of taxing provisions, three aspects are involved. First is the introduction of a flat 30% tax on profits earned from transfer of VDAs. The second one taxes the receipt of VDAs by a person for free or inadequate consideration. Of course, unless it falls within the list of specified exemptions, such as a gift from a relative. And the third one provides that persons making payments to Indian residents for transfer of a VDA will be required to deduct tax at 1%. That is what we generally call as TDS, subject to the condition that the consideration exceeds the specified monetary thresholds. Now, while the first two taxing provisions applied from 1st April this year, this new TDS levy has become applicable from 1st July only. With respect to implementation of the TDS obligation for transactions undertaken on crypto exchanges, there were certain practical concerns and difficulties because in such transactions, details such as identity and PAN, that is the permanent account number of the seller, are generally not known to the buyer. Then if we have a situation where there is a barter of one VDA for another VDA, there were also some doubts regarding the manner of TDS computation. And to clarify these certain aspects in relation to these type of situations, the government has issued guidelines recently. For instance, in case of VDA transactions undertaken on exchanges, since there are multiple layers, it has been provided that tax may be deducted by the exchange alone, where the VDA being transferred is, let's say, owned by the exchange itself. It has been provided that the exchange may enter into a written agreement with the buyer or his broker that with respect to all such transactions, the exchange would be paying the tax within the prescribed timelines. If there's a situation that the consideration is in kind or in barter for another VDA, then at least from an administrative convenience standpoint, the exchange is permitted to deduct tax, subject to, of course, a written contractual agreement with the buyers and sellers. And for these sort of barter transactions, there's a detailed procedural mechanism that has been provided in the guidelines to compute the quantum of TDS. If we talk about peer-to-peer, that is P2P VDA transactions, where the consideration for VDA is in kind, the buyer for VDA will have to release the consideration only after the seller has provided a proof of payment of such tax. Similarly, where the VDA is acquired, let's say in exchange for another VDA, there both the persons will be considered as a buyer and a seller, and hence both persons will need to comply with the TDS requirement. Because if there are two persons A and B and both are exchanging their VDAs, then from their own perspective, both the persons are a buyer as well as a seller for the respective VDAs. In terms of practical implication, the TDS levy has had the maximum impact out of the three taxing provisions that we discussed earlier. In fact, in the initial few days of its implementation, there were reports that major cryptocurrency platforms in India witnessed around 70% to 80% drop in trading volumes. And perhaps the major reason for this was the apprehension about the mechanics of this 1% TDS, especially in case of VDA platforms. Of course, the drop in valuation would have been another reason for the drop in trading volumes, but this sudden change in legislature, the sudden change in practical provision was also a big reason for the drop in trading volumes. I think one can only hope that these guidelines go a long way in removing the difficulties and the practical concerns that the stakeholders had in their minds. This was a brief snapshot from my side in relation to the CBDT guidelines regarding TDS on payments for virtual digital assets.
Raghav, thanks very much for that. And for people like me that have a hard time processing numbers, can we just take a hypothetical VDA, like a non-fungible token, that's worth 1,000 rupees? Can you tell me how this regime would work on that notional NFT in terms of the taxation, how much and who pays, and when and where?
Sure. So let's say a scenario where the sale price, where a person has sold a VDA for 1,000, and let's assume the cost was 100. So in this case, the profits earned by the person will be 900, that is 1,000 minus 100. Now in this situation, the flat 30% tax will be 270, that is 900 into 30%, and that will be payable by the seller. Of course, the final effective tax rate will be a little bit higher because the basic tax rate has to be topped up with a certain percentage of surcharge and cess depending on the total quantum of income. But the basic 30% tax, that is 270, will need to be paid by the seller to the government of India.
Okay. Thanks very much, Shobit, on that. And now let's change gears entirely and talk about the intermediary guidelines. Supratim is going to walk us through that. Supro, you and I have discussed that this is a raging topic all around the world. In the United States, we have something equivalent, and that's Section 230 of the Communications Decency Act that brings into play freedom of speech issues, contrasted with problematic speech such as inaccurate or flat out wrong speech or defamatory speech or any other issues. And I think India is going through the same tussle on these. We've done this on a number of occasions talking about these intermediary guidelines in previous newscasts. Walk us through these latest proposed amendments, please.
Right. Thank you, Paco. So on 6th of June, 2022, the Ministry of Electronics and Information Technology came out with a press note and said that it intends to amend the new rules of intermediaries, which was anyways sort of promulgated in early 2021. They want to bring in a number of changes, and they made a couple of headline statements that why these changes are intended to be brought in. One was that they wanted to create additional avenues for grievance redressal, and the second one, very interestingly, it stated that constitutional rights of Indian citizens are not contravened by the big tech platforms. They need to ensure that, and that is why new accountability standards are being brought in for significant social media intermediaries. Now, significant social media intermediaries, just to recap, is those intermediaries or platforms which have got 5 million or more registered users in India. There are a lot of issues in relation to the amendments that are sought to be brought in, but I just pick up the top three, I would say. The first one is in relation to due diligence that are to be followed or adhered to by the intermediaries. In presently, what we have is this diligence requirement is kind of limited to publishing or informing the users about the rules, privacy policy, permissible content parameters, etc. This is sought to be expanded, and now intermediaries are also required to ensure that users comply with these requirements. They are also required to have an obligation now to wherein they cause the users to comply with these requirements. It's very difficult to fathom how that could be done, but what this could mean essentially is there could be pre-censorship, there could be active moderation of content, and thereby there'll be dilution of safe harbor principles. We are all aware, and as one of my good friends call it, that we always wanted to be a dumb container or dumb pipeline when we are an intermediary. But more we are asked to look into information, probably the safe harbor principles are getting diluted. It would also mean a significant operational costs and challenges. That's the first one. The second point I would like to pick up is in relation to grievance redressal mechanism. The present day requirement states that the grievance officer is supposed to acknowledge any complaint within 24 hours and redress it within 15 days. Now, what is being presently sought to be done is that there are certain requests in relation to removal of information or communication link. If that comes through, then that has to be adhered to within 72 hours of receiving that report. Now, what that could mean is over censorship, definitely, because given the tight timelines, you would like to rather censor than not do anything about it. Then there could be, of course, increased compliance cost and enhanced infrastructure resource requirements. The third point I would like to talk about is the additional grievance mechanism which the government intends to bring in. They have said that they want to now have a grievance appellate committee, which would be by the central government. Interestingly, this is not a mandatory appellate mechanism. It's an alternative to the judicial recourse, and therefore one has to question that and this has already been raised by many industry bodies like USIBC and others, that what is the efficacy of having such a mechanism if it is just optional? It could possibly lead to multiple proceedings. Of course, there is also lack of clarity on the constituting members of the committee and whether there would be any judicial representation. So with that, I will stop. Back to you, Paku.
Super. Thank you. Thank you for that. We have a little background noise there, but Supra, one question I have is if you look at the top of your slide, on the third bullet point under the heading existing position, the resident is a keyword, grievance officer. How has that been looked at by industry and the government? I know a lot of eyebrows were cocked when there was that requirement. How's it working?
Right. I think most of the intermediaries have appointed a resident grievance officer. But Paku, what is interesting to note is that there's a requirement that this particular officer should be an employee. Some of the intermediaries we understand have appointed an external agency or a consultant, and that is getting scrutinized either by the media or activists or even perhaps the government. And what we hear is that whilst no action is being taken very proactively, but definitely this is something that the government could look at, considering this is not following the law in toto.
Great. All right, Supro, thanks very much for those very important developments on intermediary guidelines. And Achint, I'm going to turn it over to you because I think we also, in the world of cybersecurity, have cybersecurity guidelines by SEBI in terms of asset management companies and mutual funds. Very, very important. Love to hear from you on that.
Sure. Thanks, Paku. Today, I'll be covering the SEBI cybersecurity, cyber resilience framework. While this follows a host of regulations which were geared not only towards cybersecurity, aiming to protect the data, but also going a step further in building a more robust cyber resilient framework. This governs not only stockbrokers, depository participants, market infrastructure institutions, stock exchanges, and the like. This will be effective from 15 July 22. As part of the highlights, the initial main critical point is of identification and classification of the critical assets. This would include not based upon their sensitivity and criticality for the business operations. The critical assets could include anything from sensitive data to sensitive financial data, personally identifiable information, etc. Obviously, if there are any ancillary systems which are either accessing or communicating with the critical systems, they also would be governed within the broad purview of critical assets. The obligations of the boards not only are towards approving the list of critical assets, but also preparing an up-to-date inventory of those systems. An important critical point covered under this amendment is relating to the stress tests for the vulnerability assessment and the penetration tests. Now here, what is important is that we need to ensure that the underlying security vulnerabilities in the IT environment are not only detected, but there are sufficient systems in place to put that in check. This VAPT assessment needs to be conducted by a certain impaneled vendor. And obviously, in cases where the systems are protected systems, there would be an additional reporting which is to be done to the NCIIPC. The final report must be submitted to SEBI within 1 month of the VAPT completion. And before installing or updating any system, vulnerability scanning and penetration testing needs to be conducted. From a reporting perspective, not only are the corporates required or the mutual funds and AMCs required to put in place the systems and policies, but also ensure that there are the frameworks for modifying internal policies. Comprehensive audits need to be undertaken with a declaration by the MDs and CEOs certifying compliance. The critical point, which is a pain point for several corporates, is the fact that cyber incidents must be reported not only to SEBI, but to CERTIN within 6 hours of detection of the cyber incident. There's also the quarterly reporting requirement within 15 days from the end of the quarter, outlining the cyber incident as well as the mitigation steps. Just as the key takeaways in this AI-enabled digital world, while this framework does put considerable costs because of enhanced proliferation of cyber-related regulatory compliances, but it is an incremental step towards building a resilient ecosystem. That's it from my end.
Thank you for that. I had one question. These are guidelines. I'm sorry, can we go back to the previous slide? Anyway, yeah, there we go. On cybersecurity and cyber resilience for 2 specific types of companies, what is the repercussion if there is failure to take corrective action, or is that really the only repercussion is taking corrective action? In other words, are there fines? Are there other sanctions that might be laid against asset management or mutual fund companies if they fail to adhere to these cybersecurity guidelines?
Yes, that's an extremely critical point, which is of concern to all the entities who are involved. There is not only a penalty under Section 70B of the IT Act under subsection 7, which includes an imprisonment for a term of 1 year, which may extend to 1 year, or with fine, which may extend to 100,000 INR, or with both. But since this is a SEBI circular, non-compliance would entail a penalty of not less than 100,000 INR, extendable to 10 million INR. And this is under Section 15HB of the SEBI Act, that there would be penalties. So yes, it's not simply the compliance that needs to be ensured, but they do have sufficient teeth to ensure enforcement.
Okay, Achan, thank you very much. And ladies and gentlemen, we're going to get to the last of our 5 presentations today from Nishad, our IP partner in Mumbai. And so Nishad, walk us through these guidelines for the prevention of misleading advertisements and endorsements. And I know we've covered this previously, but maybe just discuss some of the new aspects of this.
Sure. Thank you, Baku. So until recently, there was no single consolidated set of guidelines which regulated, misleading advertisements, which had the force of law. This was predominantly governed by the ASCII code. It was self-regulated, and there were certain sector-based statutes and guidelines which took care of certain sector-based aspects of advertising. Now, on the 9th of June, the Central Consumer Protection Authority has released these guidelines for prevention of misleading advertisements and endorsement for misleading advertisements. The guidelines have been issued pursuant to the powers given to the CCPA under Section 18 of the Consumer Protection Act, and they are with a view to prevent unfair trade practices, misleading advertisements, and to generally protect the consumer interest. These guidelines have come into force with immediate effect. Now, given the fact that advertisements are no longer limited to television and print media, but have transcended into social media, the internet, the metaverse, etc., the guidelines are applicable to all advertisements, regardless of form, format, or medium. And they are also applicable to all manufacturers, service providers, traders, and also to advertising agencies and endorsers. The guidelines, for the purposes of this discussion, I have divided that into 8 broad topics or 8 broad parts. The first is the general principles which govern what is a misleading advertisement. So they say that if an advertisement is generally honest and has truthful representations, or does not use unnecessary exaggeration, or the claims generally comply with sector-specific law, then they are not considered to be misleading. Now, merely because there is no independent substantiation to a particular claim does not mean that the advertisement is misleading. The second part which I'll deal with is that for the first time, they've dealt with bait advertisements. Now, bait advertisements are advertisements which offer a particular product at a low price with a view to attract consumers. Now, these advertisements are required to comply with certain conditions which have been set down. So if you are mentioning a particular price, then the product should be available to the consumer at the price that you advertise it. Now, because such low prices will attract a good amount of demand, there is an obligation to maintain adequate supply as well. If there is limited availability, you have to specifically mention that. If there are conditions associated with the supply of the product at that low price, those have to be specifically indicated. The third part is about surrogate advertising. There is a specific bar with regard to surrogate advertising. Now, surrogate advertising means an indirect advertisement for a product which is prohibited from advertisement, like cigarettes, alcohol, etc. So no advertisements can be made suggesting directly or indirectly that it is for a product which is prohibited. There is, of course, a clarification which says that if there is a brand which is used for a prohibited product, it can be used for other products as well, so long as it kind of adheres to the guidelines. Now, what exactly should it be adhering to is not entirely clear, but here you may have to make a reference to the erstwhile cable television network rules, which set out in what circumstances a brand which is used for prohibited products can be used for other products. The next part, or the fourth part, is about free claim advertisements, which mean that a product or a service is being advertised as being made available free of charge. Now, the guidelines set out a negative list to describe what cannot be portrayed as free or without charge. A product or a service is not to be portrayed as free if the consumer has to pay anything other than the avoidable cost of responding to that advertisement or collecting the delivery of that item. If there are any other conditions, you have to specifically set them out. And in the course of making available a product which is free, there should not be any compromise on the quality or quantity of the product, which otherwise would have been made available to the consumer. The next very important part which has been introduced is conditions with regard to advertisements which target children or feature children. Now, advertisements which target children should ensure that the inexperience or naivety of children should not be taken due advantage of. A host of conditions have been introduced into the guidelines. For example, it should not promote any behavior which should be dangerous for children. Health or nutritional benefits should not be portrayed without scientific substantiation by a recognized body. There should not be any installation of fear with regard to a negative body image. You should not exaggerate features which will give unrealistic expectations for the children. Similarly, advertisements for junk food, carbonated beverages should not be advertised during a program which is meant for children or a channel meant exclusively for children. This is a significant development. Similarly, an impression cannot be given that goods which are being advertised are better than what is traditionally meant or given to children. The next sixth part is rule on disclaimers. Now, disclaimers have been dealt very extensively in the ASCII code recently, and most of those guidelines have been imported into the CCPA guidelines now. Basically, they talk about the fact that disclaimers can expand or clarify or resolve ambiguities with regard to claims, but they cannot contradict the main claim which is being made in the advertisement, so as to make that claim misleading. The guidelines which have been set also talk about the language in which the disclaimer should be given, font size, placement, speed, legibility, etc. The next couple of parts are about the requirement for due diligence, which is introduced for endorsers, and the requirement to disclose the material connection with an endorser. So if you have a stake in the endorser, you need to disclose that. Similarly, responsibility has been cast upon manufacturers, service providers, advertisers, advertising agencies to ensure that claims made and advertisements are verified and supported by relevant data. Now, if you're making claims, comparisons, or descriptions, then they should be capable of being substantiated by data, and the CCPA has the ability to call upon you as an advertiser or an endorser to produce such data on the basis of which your advertisement has been made. That's about it for my from me.
Thanks very much, Nishad. And we are near the end of our program, and we want to save a few minutes for Q&A. Just a couple of very quick questions for you before we get into Q&A. And audience, colleagues, please type in your questions, and Jay will ask those in the order that we get them. But Nishad, couple of questions. Same thing that I asked Achint just a minute ago. Is there any repercussions for violating these guidelines in terms of monetary penalties? Second, is there any other law in India that gives a private right of action for somebody who's aggrieved by a deceptive advertisement? As we've discussed in the United States, there's pretty significant state and federal consumer protection laws. Are there going to be anything there that gives that kind of right to an aggrieved person?
Yes, good question, Paku. I think so. The statute under which the guidelines have been issued is the Consumer Protection Act, and the Consumer Protection Act really sets out the penalties and the repercussions for not complying with the guidelines. So that's the predominant statute which governs all kinds of misleading advertisements, unfair trade practices, etc. The guidelines don't specifically set out an enforcement mechanism, nor does the guidelines set out any particular penalty as such. However, the statute talks about a 1 million to 5 million penalty in case of violations of various guidelines and various provisions of the statute. And to my mind, those would apply equally to the present case as well.
Great. All right. So, ladies and gentlemen in the audience, that ends our 5 presentations. Jay, let me turn it over to you for any Q&A that you or the audience might have.
Wonderful, thank you. Once again, we will share those slides with everybody afterwards. Our first questions have to do with the 5G and captive networks. One is what are the spectrum bands being discussed for captive networks? I'll add to that. Do they generally align with spectrum bands for similar products and services internationally? Obviously, alignment drives scale. Over to you.
Right. So to answer the first part of that question, Jay, the guidelines don't quite spell out the spectrum bands themselves. But if you have to read it along with the notice for the bid document that's been issued for in respect of the auction for the 5G bands that are ongoing. So my guess is that all of those would be up for grabs as well, along with the IMT spectrum, which is the 3G and the 4G that currently access providers may have, both of which are sort of recognized under the guidelines. And to answer that second part of your question, I think to a large extent there is a fair bit of alignment, but it'll have to be seen finally in terms of how when this is set in motion, and when the allocation is actually complete as to how this will be implemented effectively.
Jay, you're on mute.
There's a follow-up question that has to do with Model 1 and 2 for the folks just to go in. Model 1 is leasing of spectrum from a telecom provider with a license, and Model 2 is as a service. Does the government plan to regulate the issues of non-discriminatory access in advance, or is it going to be something that's sort of handled afterwards? Any insights on that, sir?
Sure. So, at a broad level, of course, contemporaneously to the guidelines for the license, there are also guidelines for leasing of spectrum. There have also been amendments that have been carried out in the license agreements themselves. But a culmination or a combined reading of these suggests that, the DOT would want to know subsequently as to what may happen. There are requirements where the TSP is required to mention what kind of spectrum bands and the details of the arrangement that is entered into with the enterprise and submit those to DOT in due course. So there's a time-bound obligation that needs to be followed there, where once the arrangement has been concluded, they'll have to inform DOT in the prescribed manner.
Thank you. Great question. Switching to virtual assets and the taxation. So we know that there's a tax on the sale of a good, but we also know people that buy and sell commodities and other assets. It's often a blended, some you lose, some you win. How is the government planning to think about, losses? At the end of the day, if you sell an asset, a virtual digital asset as a loss, are you able to, or buy it, are you able to blend your taxes? How does that work?
Sure. So unfortunately, that sort of setting off is not allowed, and this is because from an income computation perspective, the law has specifically provided that except for the cost incurred in acquiring the VDAs, no deduction, be it an expense or set off of any loss, will be available. So let me give you an example. If a person has earned a profit of 100 on sale of, let's say, a Bitcoin, and incurred a loss of 40 on sale of, let's say, Ether, then the 30% tax will be payable on the entire 100 and not on the 60 that is the differential. So the tax will be payable on the entire 100.
So if that's the case for people that do this more than just a casual sale, the effective tax rate would be ultimately higher because you're not able to offset it, right?
That's right.
Okay. Thank you for that. I want to switch to intermediary liability. I think this is one of the hot topics I think we're seeing not only in India, but around the world. The IT Act does have clear aspects of safe harbor protections. The rules sort of chip away at that. Am I reading that correctly? And how might this flow? And is it contestable in courts of law? Might it pass? I don't want, anyone to make a guess, but, kind of help us understand that situation.
Right, Jay, I think fantastic question, because when you look at the concept of intermediary under the IT Act, it says that you are a conduit. Okay, you have not originated the information, you have not selected the recipient, you have not changed or looked at things in between. So you're a perfect dumb pipeline, a postman who's carrying a package and don't know what is there, right? Now, what is increasingly being done is you're being told to look into the package and decipher what is there and censor that, right? So effectively, what you are doing is watering down that concept of safe harbor. If it is challenged in a court of law, to my mind, at least some part of what is being thought of, to be done through these amendments, etc., could be watered down.
Great, thank you. I'm going to encourage our members to type any other questions. We got a question from Ashish. Following the advertisement guidelines, what will be the position of the ASCI and the various sectoral advertising guidelines? How do you balance the two, sort of overarching and then sector specific? Nishad, you're on mute.
Yes. So that's a very good question. So ASCI is being predominantly a self-regulating body, and the code has not really had the force of law in that sense, though it has been given reference in certain statutes, and to that extent, it has been around. The compliance with the ASCII code up till now was voluntary, and most organizations, including advertising agencies, etc., used to be members, and therefore they were really contractually bound to comply with the ASCII code. Any recommendation which came from ASCII or the review process thereafter was not binding, was not enforceable, right? Now that the CCPA guidelines have come in, that's got the force of law. Both of them will continue to run parallelly. Consumers, members, and people aggrieved will have the ability to go to ASCII as well as to the CCPA. But the teeth which are provided by the CCPA are far stronger now. And the CCPA has been taking good amount of action with regard to misleading advertisements also. And that will curb a good amount of misleading advertisements going forward, hopefully. I hope that answers the question.
Yes, it does. So thank you for that. I believe we have time for one final question, and I'm going to ask Adyant a question about cybersecurity. We see that the government of India is rolling out a number of different cyber policies. Are you seeing any collective strategy or some commonality or overlaps? Are there some cross-cutting aspects that they're looking at and then instituting those sector by product and so on? Or do you find that the various cyber policies are fairly divergent? Is there consistency or divergence across the board?
Hi, Jay. What I would say is that most of these are diverging. However, there are still some gray areas. While the main aim continues to be to rope in as many participants as possible. So even if you see from a cybersecurity perspective, even though SEBI has included this, but you can clearly see that there is the certain reporting which is common across all the spectrums where certain reporting is being brought in for any cyber incident, and that would apply to not only any entity that is located in India, but also all service providers, intermediaries, data centers, or anybody corporate that is offering services to the users. And even if they don't have a physical presence in India, they're required, like it was talked about previously mentioned, to designate a point of contact to liaison with certain. So there is a commonality. However, considering there are several facets that need to be covered, I think over a period of time, we will see more commonality emerge. There are some gray areas which obviously become the pain points for the participants in this digital space. But I would assume that over a period of time, that would also be seamlessly flowing through.
Wonderful. As we come to the end of our program, I want to thank our experts. This is such valuable and insightful information. We really appreciate it. To be able to distill down these difficult and complex issues into one slide in 5 minutes is really a credit to all of you. I want to thank Paku and his team at KCO for doing this over USIBC. We really appreciate it. And thank you. If there's anyone on this call that would like to meet any of these experts directly, do not hesitate to follow up with me. I would be happy to connect you. And with that, I'm going to hand it over to Paku for any final words.
Jay, thank you so much and the U.S.-India Business Council for the warm friendship we've had and giving us this opportunity. I also want to thank my colleagues Nishad, Supro, Achint, Shobit, and Raghav for doing a great job today. And it is very complicated, but to take 5 disparate topics and do it in less than an hour is a real accomplishment. So thank you very much. Also want to thank our behind-the-scenes person, Ravina Ashok, who helped produce this and did, as usual, a great job. Most of all, I think all of us from KCO want to thank you, the audience, for joining in and being interested. We very much look forward to doing this again, hopefully in the next 4 to 6 weeks. If there are any topics that come up, please let us know, either Jay or in the slides, you'll see our email, and just please do let us know. And if you do have any questions about this, also today's presentation, please let us know. And I guess most of all, be safe and be well, and thank you so much for joining today. Take care.
And with that, good night and good day for all of our members.
Bye.
Thank you.